Okay, we're good.
So I am calling to order the subcommittee meeting of the Ethics Commission, LFUCG Ethics Commission, a special meeting where we're looking at the LFUCG Ethics Act. This is one of a series of special meetings we've had. The first item on the agenda is minutes of the previous two subcommittee meetings. I note that Delora is not here today, but David, my other subcommittee member, is. David, did you have any edits from either of the minutes? I had one, but
No, I didn't. No.
The only one that I had was a small grammatical error on the May 20th second paragraph where it says subcommittees members, apostrophe S instead of S apostrophe. I know that's critical, but
No, that's noted.
It shows that I read them correctly.
Very good. Yeah.
So with that correction, I will go ahead and move to accept the minutes
So
as
moved.
corrected.
So moved.
Second, we've got a motion and a second.
I'll second it too. Can I second it?
Yes. All in favor indicate by saying aye.
Aye. Aye.
Motion carries. Discussion of the Ethics Act review. Was that in terms of? I sorry, never mind. So I've been thinking a lot about how, given the limitations placed on us for meeting by the Open Meetings Act, how we can work on collaboration. And first of all, let me thank the law department for doing the legwork on looking at the underlying legal issue of what we might be able to do under the Open Meetings Act. And I think maybe the way to approach this is to work in groups of sections that are topical. And tonight I'd like to talk about the two areas that I think has had the most work and most notes on. The financial interest statements and the complaint, and maybe we only deal with the financial interest statements first. And we start by identifying, because we're not going to be able to do a complete overhaul of the entire Ethics Act. The council is not going to be interested in that. But through our own experience and through the questions that we have raised, starting with what are the pain points that either the commission members or the law department have based on what's there now. Identify those. Identify, when we're identifying those, what are some of the practical issues that might come about if we come up with different solutions. Discuss those and then try to figure out, okay, who then takes the next shot at drafting something so that for our next meeting of the subcommittee, we can deal with that and allow Delora, for example, to comment on that. Put that one to bed and then go to the next one. And I think that way, keeping it topical, because David, for example, I love some of your comments. What I literally did is when I asked for a copy of the Word document of the Ethics Act, I went in and typed in Evan's other changes that he had suggested. Then David, I took your comments and linked them in bubbles on that one to be able to track through, and then added some of my own. And so if folks think that is a good way to proceed, and I personally do, what I'd like to do is take a look at the financial interest statement sections, which are 13 through 18, and sort of, even without looking at the sections to start, what are the pain points? And the ones that I have thought about are, first of all, is there a question about who should file? And in particular, the unsuccessful candidate for office. Who should file? What kind of oversight? David mentioned, and I think Delora even mentioned as well, we, the Ethics Commission, are the ones who collect these, and it's our responsibility to collect these. But you know, who is to review them and what is the purpose? And I've got some ideas on that. Talking a little bit about the deadlines also. And then further, other related contacts. But and does anyone have any additional big issue categories that you can identify?
No, I mean, I think if we start working through 25, 13 to 18, section by section, some questions might come up. I might have some questions that'll pop in my mind. Sure, then, but AJ, that sounds like an appropriate way to begin. I'm perfectly happy to do that. So you want to start with 2513, who should file?
Yes, I think so.
Could I ask a preliminary question then?
Yes.
Does every individual who would be considered under these 5 items, are they all currently submitting annual disclosures? I mean, one question I had is commissioners. Do all commissioners file financial disclosures?
I can speak on this. Yes, they should be. And we've been counting them down and put them on our list every year. And so far, everybody has submitted them. So we definitely get commissioners and division directors and employees holding the office of positions or the positions of buyer and buyer senior.
Are there any citizen boards that are not technically commissions by definition that should be included in terms of individuals submitting disclosures?
So, just as a point of clarification, commissioners aren't, for these purposes, aren't members of commissions. They are, there's certain jobs in the urban county government who are called commissioners.
Right. Okay.
Commissioner of Law, Commissioner of Planning.
Yeah.
So that's what they mean, not commissioners like everybody who's on a commission.
Okay.
So it's just, like I said, there's a Commissioner of Law, Commissioner of General Services, Commissioner of Planning, Commissioner of Social Services, Commissioner, I think the Chief Information Officer is considered that too. It's basically those positions that are appointed by are like, are basically like employees, but are appointed by the mayor, instead of through the classified system like me or Gabby. Or
Okay,
Gabby or I.
Thanks for that. I keep losing that. But there are a couple of commissions. There's the Planning Commission, the Ethics Commission,
yes,
the Board of Adjustment, and the Comprehensive Plan Update Committee. They all submit disclosures, right?
I don't know if that Comprehensive Plan Update Committee is existing right now. I think that might just be every so often thing potentially if we update our comprehensive plan in a way that would require them to, or where LFUCG would want to have a committee set up. So that's not happening right now.
Point in that regard. So I'm looking. I think we're all looking at 2513.3.
Right.
And one question I have is for the Board of Adjustment, Comprehensive Plan Update Committee, Ethics Commission, and Planning Commission. Am I correct that the one thing that each of those have in common is those committees or commissions are ones in which a decision is made or recommended at that level, whereby some action can take place, like with the Planning Commission, for example, Planning and Zoning. They're going to either decide or make a recommendation to the Urban County Council as to whether something's zoned or not. Ethics Commission, we are going to decide whether or not there's an ethics violation, or at least enough to push them along. Are there other the other groups, like let's just think of one that would be different, where you've got maybe the Sister Cities group, they're not making decisions that are affecting, you know, they're not making the same types of decisions that we as an ethics commission are. And so is that why in 2513.3, those committees and commissions are identified as folks who need to file, but say the Sister Cities group is not? And if that is the case, do we want to put in or recommend putting in a catch-all that identifies that sort of category of commission or committee that is affecting rights of individuals or entities? That probably, you know, and this goes back to, I think, the bigger question that we'll get to about who is monitoring this. In my mind, the very reason that you have financial interest disclosures is conflicts of interest. It's a much bigger deal to have a conflict of interest if it's the Ethics Commission, the Planning and Zoning Commission, things like that, than the sister cities. And it's not like we, the Ethics Commission, are going to be, from a reviewing of the submitted forms, going to be policing the Planning and Zoning Commission to make sure that any particular member doesn't have a conflict of interest. So that's why I think that we need to think about, you know, first of all, is there categorically is what is the purpose of the financial interest disclosure, and do we have, to David's sort of general point, do we have all of the right categories of people having to submit them?
So I just pulled up the list of boards and commissions, and the second item on the list is the Administrative Hearing Board, which does make decisions. And that's not obligated under the Ethics Act to, those individuals aren't. I mean, we've just recently dealt with some of that. They're not obligated to submit annual financial disclosures. But to AJ's point, if they did submit those disclosures, you know, who would look at them and what would we be looking for? I mean,
Well,
you know,
and
yeah.
I think in that regard, I don't think it can or should be the Ethics Commission, because I think it's important for one group to be the collector. And I think even if we're not the ones reviewing the forms, it has some sort of importance that this form is coming from the Ethics Commission to sort of highlight for the recipient of the form request, this is important from an ethics standpoint. It may be different, you know, if another group sends it, it may not have that same impact.
Yes.
What one idea I had, David, because think about it this way, and I'm just going to use the Planning and Zoning Commission. So a commissioner for the Planning and Zoning Commission submits a financial interest statement, and it lists any number of businesses, entities, interests, etc. on there. It's not like a representative of the Ethics Commission is going to go to all the planning and zoning hearings and sit there and say, okay, this is on the agenda. Let's look at all the people who are on the commission, the zoning commission, who submitted an application to see if they've got a conflict. In large part, I think that the commissions themselves need to police that. The chairs of those commissions, maybe it's the chairs of the commissions that have it. One idea that I had from an ethics commission standpoint is, in conjunction with us collecting the forms, figuring out who hasn't submitted them in a timely manner, that the chair of, and we put this even in the Ethics Act, that the chair of the commission issues a report to the Urban County Council that identifies who has not submitted a financial interest disclosure by the deadline and what actions the commission is planning to take to get those financial interest statements in. But I don't think it should be the ethics commission who's, I mean, what, we've got no power and probably shouldn't have any power to enforce the fact that someone's got a conflict of interest on a board. I don't know if we do or not. But the amount of time that it would take the commission to do that, I mean, essentially we would have to receive every single agenda of every single commission to then get that and look at it to say, okay, does so-and-so have a conflict? They're on the commission. Here are the 25 different things before the Planning and Zoning Board at the meeting on July 21st.
Yes,
We're just not going to do that.
so the conflict of interest processes that I'm familiar with all involve disclosures of one form or another, either annual or episodic disclosures as possible conflicts arise, or both. And then there's individuals who are consigned the responsibility to review those. And if in the review, and there you can set up a kind of algorithm or a set of rules as to what disclosures might require some additional attention. The person or persons responsible for reviewing those disclosures then refers those disclosures to a committee or commission that operates in these systems to look into this and to see if there's any recommendations. So the commission or the committee itself isn't reviewing all the disclosures, but John Brown has disclosed something, and the person or persons reviewing these disclosures knows that because John Brown is on one of these commissions, and that might be something to pay attention to. So that becomes an item like the ethics hotline reports. That becomes an item that gets referred to the commission, and the commission can make a recommendation to, for example, the chair of the board of that commission, to make sure that the rules of recusal are observed in regards to matters. That sort of thing. That becomes the process that's followed. So that, I mean, it adds a little work to what would be the commission's responsibilities, but the commission isn't looking at all these forms and the like. But somebody is. I mean, my concern is that, for example, somebody on one of these commissions who's obligated to discloses, and then is sitting in a meeting where the requirement is to recuse yourself or disclose a conflict that if it might be applicable to the subject matter or business of the meeting. And that person's sitting there thinking, well, I've already disclosed that. I submitted my annual report. Well, of course, there's no looping back. There's no connecting the annual disclosures back to that meeting where a business issue is being addressed, which might be relevant or material to that disclosure. And the person is maybe innocently, maybe not, but innocently is thinking, well, I did what I'm supposed to do, so I participated, as opposed to, the disclosures triggers attention to the need for possible recusal at that meeting when that issue comes up. I mean, to me, that's always been, as I've seen it, and I'm familiar with it, sort of the better practice that's going on in these systems where financial interests are disclosed, reviewed, and attended to at the appropriate time by the appropriate people. That's how I'm familiar with it working. So,
well, and I think in that, if that's going to be the case, I think before we go down that path, because it's unlikely to be volunteers.
all right, I would agree.
And so that it's probably depending, and this is a question I have, how many volume-wise people file disclosures?
It's usually around 130 or something like that.
So to David's point, I mean, if you had in the budget, if you found some software that someone could analyze and type in and run searches each time there was a meeting of one of these commissions, then maybe that's doable, but that's not done for free. And so I
Yes.
think it would have to be in the budget.
Yeah.
And so you'd want one department in the urban county government to own it and be willing to own it and put the money in the budget for person, time, software, whatever.
Yeah.
And so what I don't want to do is, at least in the first cut, trying to get the council to approve an amendment to the Ethics Act that will increase the time and expense that might be borne by a department within the urban county government without them recognizing that.
Yeah, I can tell you there's software available. And it's not necessarily cheap. It's one of those things where there's an installation fee and then there's a subscription fee and that sort of thing. But in some instances, they are incredibly sophisticated. They really are. And the kind of reporting that can come out of those systems is really sophisticated. And in the instances I'm familiar with, all the practices, what you had was a paper system that became overburdensome for the organization, and they went to an automated system, and that's why there's all these systems out there. So I would agree with you, AJ. I mean, you don't want to add to the burden of a paper system without recognizing that the paper system has limitations. And if you're really going to get on top of, making an annual disclosure meaningful and making it part of an ongoing review of people's financial interests relative to their responsibilities, you really need to think about automating the whole process.
And that's why I think that what I don't want to do is make present a proposal to the urban county council that says, oh, you need to do this to make these disclosures meaningful. And oh, by the way, you're going to have to also put it in the budget to get software to make it meaningful. So I think that they're going to take a lot more, many more conversations, diplomacy, identifying which group within urban county government can do this. It may be the law department, but I'm not going to say, hey, law department, you guys need to put in the budget that you have software to do this. And so, I think that I can envision when we're presenting our proposal that we can explain that one of the things that we have struggled with as a subcommittee, as a commission, you name it, is we want these disclosures to be meaningful. They can't simply be pro forma. But in order to do that, there should be some mechanism where the effectiveness of the forms and their submission is tested. One of the ways to do that, is through software, but that's going to take money.
Yeah, I mean, the way I think of it is in terms of the recommendation of the Ethics Commission could be both text changes to the Ethics Act as well as recommendations as to, hey, we believe this is, making sure that the financial interest statements are, or at least, are tracked to determine whether or not ongoingly tracked. And there's ways to do that, including the use of software that we'd recommend using, so we can basically make sure that like AJ said, they're not just pro forma, that the filing of them are meaningful and they're used for something stronger than what they are now. So that, not all of your recommendations have to be text changes to the Ethics Act. There could be programmatic stuff too. I mean, you could theoretically even put in the Ethics Act that these are public documents, so it's not like we're necessarily providing something private to somebody who shouldn't be receiving it. But you could require that that the Ethics Commission provide the financial interest statements directly to the chairs of the commissions or council or et cetera. So at least then the chair of that group can, we know that they have them, that they, which is more than, necessarily we know about right now, whether or not they ask for them. But now the Ethics Commission, Ethics Act, you could require to provide them. So at least then, there could be the ongoing check by the chair of, hey, wait, I remember, isn't this something, the commissions themselves probably would have a better idea of what's on their dockets and how that would relate to that, smaller group than something than a review globally by one group for everything. You know what I'm saying?
So could I go back to 2513.3 number 3 and AJ, you made the point that what's listed there seem to be commissions or boards that have decision-making authority. And that's why they're there, and that's why those members are obligated to submit annual disclosures. What I think is interesting is that perhaps beyond when this Ethics Act was originally created, there now seem to be other commissions that have decision-making authority that aren't on this list. So just in terms of consistency, we are requiring disclosures from some commissioners who are on commissions with decision-making authority, but not requiring it from other commissioners who are on commissions with decision-making authority or boards. So at one point you suggested putting some language in that maybe that members and chief executive officers, if any, of the Urban Government Board of Adjustment Comprehensive Ethics Commission, language in there which simply says that the requirement is for any board that has decision-making authority. And well, for example,
and that's why I do think that that's important, David. First of all, one of the things that you identified, it could be that after this change, that there are other commissions or committees or boards that are created.
Right.
That because they're not enumerated, obviously,
right.
because they don't yet exist,
right.
that they fall off. But I think along those same lines, and maybe we might have to lean on, unfortunately, the law department in this regard, going down that list for us and identifying which ones that you think of would have that sort of decision-making authority right now, so that if we do get the Urban County Council to approve this, that you don't have commissions or committees that clearly do have that sort of decision-making authority that aren't listed, so that there's no question that they're included.
Yeah, and when you mean decision-making authority, I look at those as being more adjudicative, right? Whether or not it's Board of Adjustment or Planning Commission,
Correct.
Where they have hearings, all that stuff. Ethics Commission has hearings. Council just obviously decides. They do have adjudicative power to a certain degree for some employee appeals and stuff like that, for like police and fire and stuff. But they also have the ability to vote on every legislation of every contract, basically every contract over a certain amount of money that goes to the government, right? So that's obviously big too. So law department can definitely look at so if you, a lot of our, not necessarily every board and commission is in Chapter 2 of the Code of Ordinances, but a lot of them are. And I think it goes up to Section LI, which I think L is 50. So I think that's 51, at least around approximately 51 boards and commissions. So we'd have to go through them to determine whether or not basically they have some kind of adjudicative power. And I'd say 99% don't. They're mostly are boards that advise other boards to make determinations. Parks and Rec type of boards that make recommendations to Parks and Rec, where you're like, okay, they don't actually make the final decision. It's Parks and Rec and the Urban County Council, right? So those are, so I'm sure that most of them are not, but it would have to be something we'd have to check, and just know that there are a lot of boards and commissions And I think also it's important to note that, you know, and as we've had this discussion before, not all of the boards and commissions are even subject to the Ethics Act. So this would be something in tandem of also increasing the scope of the Ethics Act in Chapter 1 of the, in the section about definitions to include more than that in the Ethics Act. So I think that would probably be, if you're going to increase who's going to have to do financial interest statements, you'd probably also have to increase who's actually subject to the Ethics Act anyway. So I think that's important to note as well.
Well, I do like the idea. I mean, again, going back to the purpose of the financial interest statements and how they could and should be used, I like the notion of the adjudicative commissions and committees. And there's the catch-all.
Yeah, so the Administrative Hearing Board holds administrative hearings and renders decisions on appeals from civil penalties issued by the Division of Code Enforcement. So there's, I think, that's a good example.
Exactly. That's one that probably should be enumerated in the list.
Yeah.
And that's what I would, again, ask the law department to kick around. Which other ones might we want to spell out? And then have the catch-all thereafter.
And I just want to make sure, you know, just so you're not, you know, when you see that and they're not subject to the financial interest statements requirements, the administrative hearing officers who make up the hearing board, I go to those sometimes. You know, I have wide practice. It seems like the
speak for yourself.
Right. I'm no general counsel of a law firm or anything, but but you know, they, at the beginning of it, before they go to the hearings, they do conflict checks. They're, you know, at this point, the hearing board, they're all attorneys. They all do conflict checks. So to the extent that they don't have a conflict as pertains to the clients and stuff like that, so they check into those types of conflicts of interest before they hear it. So, you know, and I'm not saying we shouldn't do anything because they do something. I'm just trying to, you know, help you see that, you know, there is thought that goes into that on the front end. It's for that one in particular. It's not a wild, wild west situation.
Mm-hmm.
Right. But there could be some boards that do have some kind of adjudicative authority.
Yeah.
And the chair of those boards, for example, is not attuned to asking those questions at the beginning of meetings and the like. So,
yeah, and that administrating hearing board too, they have the way they do their hearings is it's not before the board. There's hearing officers that just one hearing officer hears the cases. So that's how that works.
Yeah,
so you know.
We're familiar with that process.
So I like the direction that we're heading with respect to 2513.3. One, and assuming that we're all sort of on the same page there. One thing that I did want to address, which is I think been a pain point for McKinsey, is the issue of the candidate who loses, because we've got subsection 5 there. All persons formerly occupying the positions identified in subsections 1 through 4 for the full calendar year following the end of their term. But that includes subpart number 2. And so if you're a losing candidate in November of 1 year, you're having to produce a financial interest statement for a full year and a half.
So let me ask, why do candidates have to file in the first place? I mean, certainly the mayor and county judge and members of the council, they have to file, but why would a candidate, insofar as they're just at this point a candidate and not an officer, why would they have to file? And what's done with that? I mean, could a financial interest disclosure disqualify somebody from candidacy?
I think it's meant to help inform the public to the extent they ask what an individual's financial interests are when running for office, because at the same time,
is that a public record?
It
Yeah,
is.
it's public
Yeah.
record. So
But does anybody know
basically-
that there are these statements by candidates?
The press
I
does.
assume so. We do get open records requests occasionally, but I think that's the idea is that, hey, let's just say, for instance, you know let's leave like the mayor out. Let's just go do something. Let's say something like constable, right? Constable's having to file it, right? Every year, even in the year they're running. So I guess the idea is that it's only fair to have everybody who's potentially running in those years to also file too, because otherwise you'll know the financial interests of one person without knowing the others. And so I think it's just to help inform the public.
Well,
So-
and so here's, go ahead, David.
I was going to say, so that seems to me an election board issue and not a ethics act issue. I mean, if the election board's purpose is to make sure that the electorate are informed as to the background of candidates, then collecting financial interest statements from candidates would be important. But for whatever the election board is, whoever the election board is, and making that public. But our job isn't to monitor people running for office. Our job is to monitor people who hold office and hold the authority of the LFUCG, and in exercising that authority, whether they have conflicts of interest.
Well, I'll amend that a bit, David. Our job is in this subcommittee is to be able to present something that the Coburn County Council will pass. Think about that.
All right.
And so if you cut too deeply to make it perfect, it won't pass.
Yeah. Okay. Got it.
And so I think what has a better shot of passing is to amend subsection 5 to say all persons formerly occupying the positions identified in subsections 1 and 3 through 4. So you're
Okay.
taking out the candidate's obligation to continue to report.
Okay.
Because to your point, what does it really matter in 2026 what the financials were
That's
if
right.
someone lost in 2025 and
Right.
they filed in 2025?
Okay. So that is a clear, perfect example of an amendment that needs to be put in place. So that's good.
Evan, just
Because
out
I
of
know that-
curiosity, do we happen to know if there's any other requirements of filing with other boards or commissions financial interest statements, or is it just the ethics? I feel like I should know that, but
What was your question?
is there any other obligation to file financial interest statements with any other board or commission?
For candidates, I
Right.
assume that there are some. I'm not sure. I
Okay.
haven't had to deal with that, but I think that there's financial statements that certain candidates have to file. As it pertains to donations and all that stuff.
Mhm.
Okay.
Yeah.
But we don't represent officers in their roles as candidates, so that's not something that and we're not the ones that collect them from them either, so I'm not sure about
Right.
that.
Well,
I
and
assume
think of-
though.
We had to submit a financial interest statement for the ethics commission appointment, right?
Yeah.
Yeah.
we did.
Yeah. Okay.
But yeah, I would suggest that in subsection 5 we change the identification of the subsections, because what that will do is eliminate the need to continue to go after candidates who are no longer. I mean, think about it. You've got a conflict of interest statement basically in a situation where you'd never have a conflict of interest because you didn't win.
There you go. There you go.
As an aside, one thing that we may want to think, that the urban county government may want to think about is when people who are subject to subsection 5, when they're leaving, give them a copy of the form and say you will need to file this. That may be burdensome. It may be more of an HR thing, but well, and here's another question: is the one full calendar year too long? I mean, how does that play out? So if they leave in February of 24, do they have to file in both 2025 and 2026?
So the filing right now is obligatory as of April 15th of each calendar year. Why April 15th?
That's tax day.
Easy to
It's-
remember.
Yeah, and you have probably a better idea of knowing what your financial interests are because you're also filing your taxes.
Oh, so that was the reason for that. Huh? So it does not, it doesn't track the calendar year nor the fiscal year, right? It's just it's the
tax
tax
day.
filing year or
Yeah.
the filing date year.
Mhm.
Yeah.
Yep.
So
Mackenzie, how does that work? Just again for the full calendar year.
So we've been doing it that if you, like right now, we have somebody who retired in February of 2023. They still owe us a financial interest statement for the 2024 year, which would be the year after they retired. But they're getting it in 2025 because we filed for 2024 and 2025. So we get a lot of confusion because people are like, well, I retired in 2023. Why am I still getting this? Because
Well, I'll give you an example. October of 2025 will be my last meeting.
you
So
will
I'll be
have,
filing in 2026 and 2027.
yep.
yeah, we would especially want to track your financial
I'll tell you
interest,
what,
AJ, you know, so.
all the questionable transactions that occur, on the eve of my departure.
Yeah, we already have that peg for special attention, when you leave, so.
Well, and so that does raise a question. Does it make sense for me to have to be filing to 2027 if I've been gone for a year and a half?
Well, so it's one full calendar year following the end of their term of office, which could be the end of an election or the resignation or retirement. One full calendar year. So
See, I wonder whether it would make more sense instead of one full calendar year, making it such that they only have to do one more disclosure by April 15th after they have left office, retired, you name it.
To cover the year that they left.
Yes. So that, for example, with me, it would be I am leaving October 2025. I will have a disclosure that's due April 15th, 2026. So I will have submitted one more financial disclosure after I'm gone. But not two more.
Right. And the financial disclosures made on April 15th, 2026 will cover the previous 12 months.
It will cover calendar year 2025.
Or calendar year 2025, which
it's like your taxes.
Most of which were, so that does make sense. I would just make it that the requirement is to file on April 15th following the end of their official responsibilities or whatever the language is in LFUCG.
And that would eliminate McKinsey and others having to track down
Right.
the people who understandably are saying, why is it that I have to do this again? I've not been around for 17 months.
Well, you could have somebody who retires on the 2nd of January and you'd have that problem. And it's 23
exactly.
months. So, yeah.
And the way to get the Urban County Council to accept that is you don't want us tracking you down 15 months after you've left for not just the first one, but the second one that you've had to file.
Basically, we want to make sure that you have a financial interest statement covering the period of time that you've worked.
Yes.
Okay, so we're done with 2025-13. And,
Yes,
and good work, I would say. Let's pat ourselves on the back and move on to 14, 2025-14.
that's when to file.
So
I
we'll
didn't.
keep April 15th.
Mhm.
So let me ask you this, how many people actually submit an amendment 30 days after there's a material change in the previous? All right, well, of course you do.
I
You know,
did.
like,
I did. In fact, I freaked out because I'm like, crap, it was 45 days ago.
But so, I mean, to me, that's kind of important because then what you have is a process where the disclosures are annual and episodic or annual. And, when things change, which I think is necessary, I think the 30 days after is the hard part, reminding people of that. And there's no way to track it other than some kind of review of a subsequent annual disclosure where you see that they picked up a new interest midway through the year and they never filed an amendment to the previous one. So
There again, David, I think that the amount of, depending on the software that one gets, the amount of tracking down
yeah,
the discrepancies, and,
yeah,
and, and the question becomes, to what end?
yeah, yeah. I mean, my own sense is that it's important to leave this in
Mhm.
the Ethics Act, but not to fuss too much over the enforcement, and that maybe some of this could be taken care of by an application that we would eventually bring online to
Mhm.
handle this whole thing. So,
Well, in fact, if we can then go to 2015, my own bubble is for form of the statement. Do we want to have the form electronically available online? Probably in addition to, because first of all, you can more easily fill it in. You don't have to type it. I mean, you have to type it in the form, but you don't have to go to a typewriter. Because if I'm having to type it, you want me to type it other than trying to read my handwriting.
the only issue is that it has to be notarized.
Well,
Yeah, we'd have to get rid of that. The reason it's notarized is so we can potentially prosecute somebody for false swearing if they do it wrong.
well, and that doesn't mean though. See, there's a difference though in making the form available and making the submission available online.
The form's available online.
We may want to change the letter then that we send to note that and to provide them a link to what that is. Because again, if that's why I think I reached out to somebody when it was my time to submit. I was like, do we have this form electronically to fill it in? Because otherwise, it's just typing it.
yeah, so
Um,
so I would include in this in 2515 just language which anticipates having an application. So I mean, it starts out by saying it's on a form prescribed by the Ethics Commission or the administrative officer official designated by the commission. So I would just include language there or an electronic application if one becomes available, something like that. So that it anticipates that. So, but I have to tell you, the federal government does not require notarization of disclosures that are made to them, at least in the context of biomedical research and other things. The disclosures have to attest to it. They have to swear to it, and there's an attestation in all disclosures. But there's no notary public requirement that the federal government has on the whole American healthcare industry in submitting all the disclosures that go in on that. So, I mean, that's the model that I'm familiar with, not getting a notary for this, but because, when you think about it, all you're doing with the notary is not, all the notary is doing is attesting to the fact that you are the person who's signing it, not to the validity of the form.
now,
So,
here's a question though. In 25 section 25, 13 through 18, do we have in here anywhere that it has to be notarized?
oh,
It may just be on the
I'm
form.
I think we've just always done that because of the notaries. You know, you have to swear, subscribe, and whatever the other term is on the to the notary. So that's why we included it. Like it theoretically doesn't need to be there. That's just if we're just trying to make sure we can potentially there's
Yep.
an option for criminal prosecution, and
Well,
we could always look into whether or not just putting on the form that you swear it that everything is true. There's obviously like perjury requirements and for certain things for the federal government, and we could always try to incorporate those types of things to try to protect ourselves. But I think we've always just had the notary section for that reason, and also
well,
to make sure that it's the person signing, it's the person who actually, that the person signing, it's actually the person that they say they are, and it's not someone else. But
well, in fact, so here's my point. So I see, and this is jumping ahead. I see in 2517 that the filer. I'm looking at subpart H. The 2H. The filer has to, under penalty of perjury, blah blah blah. But I don't see where it says that they have to sign and notarize it. My point being, if you go back to 2515 where we were, the Ethics Commission, can prescribe the form just consistent with it. And so if we determine that it doesn't need to be notarized, we can just change the form.
Yeah, it doesn't need an ordinance change.
But we don't need an ordinance change, exactly.
Yeah. All right.
Wouldn't need an ordinance change.
All right. Good. Then that solves that problem.
So 2516, I didn't have anything.
Oh.
2517.
Wait, I had something.
Oh, yes, go ahead.
I have something for 2516.
Sure.
No, 25. I'm sorry, 2517. Go ahead.
So 2517, my question that I put in there was simply anything to add here in terms of the list of things.
Yes.
To disclose. And so Mackenzie, what is your thought?
Email address. We don't take anybody's email address right now, and it'd be so much easier if we could just email these forms to people. Like if we had their email address, it would just make life easier for us at least.
And I'm guessing, so when was the last time that this was amended? 2019. So there was email in 2019, but probably no one thought of that. So I am happy including email in that list.
And
and what we could do too is and I don't know whether we addressed this in the Ethics Act or not. I can't remember. Whether we identify here or elsewhere what information would be redacted from any publicly available of the list of things that we have listed, whether we want to provide people peace of mind somewhere that says these are publicly available forms. However, the categories X, Y, and Z would be redacted from any.
So we don't require the actual amount of the interest. Only there's thresholds that need to be. So that would be something that if we did require that, you would have to worry about that. But it's so to the extent to which we're all public officials, the fact that we have these interests and we want to continue to serve in a public capacity, it seems to me that this information.
Oh yeah.
I mean, it's fair play
but I mean, I'm talking about address, email address.
Email.
I think, and Mackenzie can correct me if I'm wrong, but my memory is that I think we usually redact home address and if there's any private cell phone numbers, but other than that, it's all provided.
Well, and that's my point is identifying somewhere what it is that we will redact. And that would be home address, personal cell phone, and if we're going to add personal email address, I think that we include that as well.
Yeah, we just have to always make sure adding it to the ordinance might be a little bit difficult. We might try to, and this might not, to your point of trying to help make people feel better, we could always add something that says that, that the documents will be redacted in accordance with the Kentucky Open Records Act, which doesn't tell you the specific things, but it at least allows you to not have to change it. If, for instance, the Kentucky Attorney General says, "Oh no, you're wrong. You're supposed to keep their addresses," for instance, and just so that way we don't have to change it. And plus, the Kentucky Attorney General doesn't take into consideration what we put in an ordinance as what we're redacting or not. It's because we can't limit the Open Records Act's scope.
Well,
So
what I would suggest then is taking a look at 2516 and adding something in there about these being publicly available documents, and that, consistent with the open records request, information that would be permitted for redaction under the Open Records Act would be.
And I think we could probably do email addresses now without an ordinance change, because remember the forms prescribed by the Ethics Commission, and those are just the things that have to be in it. So
this is true. That it says that shall include, but it doesn't say.
Yeah, it's the
shall
only
include,
thing.
but is limited to.
Yeah, so we could theoretically. I mean, it doesn't mean we can't amend it to include it. So just in case we ever change it and then we forget that we changed it, and then we make another edition later that somehow takes it out or something.
Well, and what it does too is if people refuse to put their email address, we can say that the act requires it.
That's true too.
So are we on 2517 still?
Yes.
No. So where did these numbers come from that constitute the thresholds for disclosure? Does anyone have knowledge of that? I mean, it's just, there's nothing magical about these numbers, and it's kind of interesting. When you think about, the variability of what the disclosure might mean given these numbers. So $500 a year. So I'm disclosing, I don't know, I cut somebody's lawn, and of course the year I made $600, whereas somebody, earned, $500,000, and both those disclosures would be disclosures of income. But the significance of those disclosures are gigantic. The difference and when it comes to the other financial interest, the $5,000 or more of interest of fair market value, or 10% of ownership, depending on the company, 10% of ownership could be a gigantic financial interest. Yeah. So the point I'm trying to make here is that with these numbers, you have to realize that if you're reviewing financial disclosures, it's really hard to tell the significance of what's being disclosed and how much of a big deal a particular disclosure is, because the disclosure itself might not tell you a whole lot as to how big the financial interest really is in the particular amount.
David, let me disagree with you on that, if only because if you think about it, what these amounts were probably identified based on is de minimis. If something is de minimis, it's not even going to need to be reported. But if it's significant enough to be an identified investment, that identifies that there is a potential for a conflict of interest. And so it could be 50,000, it could be 5 million.
I understand. Yeah, I understand these are de minimis amounts. I'm just wondering, what was the standard to decide that these de minimis? Because the numbers I'm familiar with in other disclosure processes are entirely different than this.
And I'd need to go back.
Tend to be much higher. So
I need to go back and check, because it's not exactly, our ordinances, when they're actually passed, don't have like underlines and crossed outs, so it's hard to tell what was there before. But these numbers very well may have been from when the ordinance was originally passed in the 90s. So they might be 90s dollars, late 90s dollars. But then again, there's an ordinance in about 2017 that changed the ordinance up, and I don't remember if those numbers were changed then. So that's why I need to go back and see if they are actually 2017 numbers or 1990s numbers. But I think that's the idea of them, was to try to make a determination as what does the government feel is de minimis. At that point, when it was set at those amounts, the government felt that those numbers under it was de minimis and above it was not. So,
Right.
But,
So could these come out of the Kentucky revised statute? I mean, are there prescriptions as to amounts in the statute as to what needs to be disclosed?
not that I recall. I think that 65 largely gives the discretion to the government about setting those things there, but just that there is a requirement for financial interest statements.
Yeah.
But that's my my recollection.
I would be comfortable leaving them as is, because it would prompt the potential for more disclosing conflicts than less.
That's certainly true.
So then we come to the final section, probably for today's discussion, of non-compliance. I'm going to suggest an amendment where we get Mackenzie a Louisville Slugger baseball bat and grant her immunity.
Legal immunity to smash somebody with a baseball bat?
I was joking.
There's no such thing.
I didn't say what you were going to do with the baseball bat or what the immunity would cover.
This really doesn't. I mean, the harshest penalty I can think of is that if you fail to submit the disclosure by a date required, at that point you're no longer allowed to carry out whatever responsibilities you have as an official in LFUCG. I mean, but that's the harshest one. You can't, if you're on a commission, you can't, continue to participate in the commission until you file it. But the commission or the council would never accept that.
Well, and if you think about it too, the other group, if I'm a withdrawn, retired, I'm like, fine, make that the punishment. I'm not there anyway.
Yeah, well, but there has to be some downside other than getting Mackenzie off a person's back. I mean, that's
well, and we can do a show cause hearing and fine them.
You can increase the fine if you wanted to.
Well, and the fines elsewhere, so we'll
yeah, that's just a think about when we talk about the fines.
The other thing that I with this, I do think there is something about public shame, and I wonder whether we add in here that the chair of the Ethics Commission will submit a report to the Urban County Council that identifies who has failed to file timely, what their position is, and identify what efforts were taken to notify them. And then each time we set another deadline, as we often do, and I think that we continue to do that. I think that we authorize Mackenzie and others to make those reminders, and maybe not in the ordinance, but as a practice, then every time that we have to do that again, suggest to whoever the chair is of the Ethics Commission to submit another report.
And we don't need to change the Ethics Act in order for the commission to do that.
We don't,
Yeah.
but to your point earlier about some accountability and what the Ethics Commission itself can do, I do think it important to make that a commitment from us that the Ethics Commission, and maybe and maybe not the chair, just say, like we say, the Ethics Commission or the designated administrative official submit a report to the McKinsey, for example, to submit a report to the Urban County Council that says these people have not complied with the financial interest statement, and it may be some of them. And these are, this was the deadline. They have not submitted. These were the steps that have been taken to notify them.
And I would, if that's in the Ethics Act, I would leave out exactly when that could happen. I would just make it as a matter of discretion by the commission, that the commission may submit reports to the Urban County Council of delinquency in the filing of financial statements. You just leave it at that, and then we can decide for ourselves at what point we want to start submitting those reports and in what form. I mean, personally, I would just put a deadline. At that deadline, you get reported to the council, and those just go out automatically. So there's so Mackenzie's not in a situation where she has to worry about, whether to do it or not. If the deadline hits and somebody hasn't filed, they go on a report, and it's automatic. And but that becomes our practice, and that's us exercising the discretion that the Ethics Act allows for in its language.
Well, in fact, what then the commission can even do is at the February meeting prior to the April disclosure deadline is sort of have a standing proposed motion.
Right.
That says the commission hereby authorizes McKinsey to submit that report on its behalf.
Right.
So that it's automatic that whenever, April 15th at 5:01 hits, McKinsey, you're hitting the send button.
Yeah, I would have that. I would have the report come from the commission or the chair of the commission, and not McKinsey. So let's.
Well, and that's the or either one. But my point being, have it. We're going to do this. This is happening. We're authorizing McKinsey to send it on the commission's behalf.
Yeah.
Use the chair's electronic signature.
Right.
The point of the ordinance change, even though you don't need it, is to basically warn people that you're going to tell on them.
Exactly.
Because if they don't know, then what good is it?
Yeah.
So
good.
All right.
Good work, AJ.
Good work, each of y'all.
Yeah, good work.
See, everybody, we can do it.
And like I said, the more I thought about it, it's like we know that there are different parts of the Ethics Act that causes the commission and the staff members pain. Right. So let's identify what those are. Those are the ones that we are more likely to get movement from the council on.
Right. And so the next time, can we do hearings for misconduct?
Yeah, complaint process. Yeah,
the complaint process. Because that I have a particular association with that based on some past experience. So
I think all of mine have run smoothly, Dave. I don't know about you.
No, you got sued once.
Yeah, I went up to the Sixth Circuit. Yeah. So
I haven't had to use a gavel.
I used the gavel. It was of no worth.
I know you did. So Mackenzie, I'm not getting some of the emails that you're sending out for these meetings. I don't know. I'm not on some lists, but maybe others. So if you could check that to make sure.
Yeah.
Okay. All right. So thank you.
Do you guys want a date for the next discussion, or do you want to just have me email you tomorrow and we'll work it out.
Let's email tomorrow because I do want to have Delora involved.
Yeah.
Okay.
And I hope everything's okay, but it's odd that we didn't hear from her.
Yeah.
And it could be that she was on vacation. I can't remember what her vacation schedule was. So.
Okay. I move we adjourn.
I second. Any further discussion? Great meeting, y'all. All in favor, signify by saying aye of the motion.
Aye.
Aye. Have a good evening.
Take care, everyone.
Bye.
Goodbye.